Yes.
May it please your lordship. Well, let's just reflect on one um, issue that I want to raise. Have your lordships ever heard for the president withholding a bill?
Sorry?
Since independence, have your lordships ever heard of the president withholding the bill?
I think there was one occasion during one president's period.
That was for some other reason.
Maybe, but there was.
But
I recollect in my memory.
yeah,
I was.
yes, I'm aware of that particular, but that was with another intent altogether. But be that as it may, Malas, what's the reason for that? Let's just, because the parliament is sovereign.
Will of the people.
Will of the people. Parliament is sovereign. Executive cannot. And this president, a president is an elected president. Even then, because there's an element of urgency, the will of the people has to be implemented immediately. And if the president doesn't exercise that leeway, in what circumstances should the governor exercise it? He's only an elected, he's not elected. Now, the other constitutional issue. Mullahs, when it, sorry, Mullahs.
Yes.
The other issue is when the bill becomes law, there is a presumption of constitutionality.
Yes.
Presumption.
There's always a presumption about it.
Always a presumption of constitutionality.
And the burden is on who challenges it. And
Correct.
it's a very
Correct. Correct.
strong burden.
Correct. Now, I explained to your lordships how actually a bill comes into being yesterday when I elaborated the manner in which the law ministries, all these aspects are looked at before a bill is introduced. And the legislation is not concerned with the constitutionality of the bill. That's the domain of your lordships. In fact, these questions are raised in Parliament several times. And some of our members say, but this bill is unconstitutional because
According to you, the legislative competence of the bill cannot be examined by the governor.
Exactly. Cannot be. That's why this bogey of timelines and all that is not necessary.
Because the written constitution is lost if we take that position.
No, I'll tell your lordships what that position is. I'm just explaining at the moment, Mullahs, that as far as the legislation is concerned, the parliament, when it passes a bill being a sovereign authority, is not looking at its constitutionality. Several times, Mullahs, we pass a bill. Ultimately, it may be provisions are struck down by this court. Sometimes the legislation itself is struck down. But at the stage of introducing it and passing it, we don't test it. Right? So if we don't test it, Mullahs, what are the three grounds on which you can test constitutionality? Just look at it from constitutional principles. Number one, will the president say, in case it's a bill introduced in parliament, that you are entrenching upon a power of the state in list 2? That's the 254 issue. Will he send it back on that ground? That's one area of testing constitutionality. 2, will he say you are violating a fundamental right of citizens? That's 2. 3, you don't have capacity. These are only 3 grounds, Mullahs, on which a legislation can be challenged. There is no 4th ground. All this will be challenged in a court of law by citizens or by somebody else. So it's in the rarest of rare cases, Mullahs, that a governor will say, no, I cannot decide it for whatever reason. Supposing, Mullahs, in a state university, the chancellor is the governor. Just to give an example. And Mullahs, a legislation is passed that the chancellor should not be the governor. what possibility will he have to clear this legislation? Supposing in a state, there is an issue of private money lenders are charging an interest of 30, 40%. And the state wants to pass a legislation, no, this shouldn't be done. It should not be more than 12%. Fundamental question is, what is that leeway? And if you give that power, sorry.
Makes the law relating to shipping, any number of entries in the.
That's right, that's capacity violation of constitutional provision. I'm not disputing that, Mullahs. But will the president raise it, or will it allow to be raised in a court of law? Because, Mullahs, at that stage, this issue is not to be considered as a matter of constitutional law. The remedies are available under the Constitution. If it's remediless, I can understand. Because it will result in a quagmire, Mullahs.
But suppose if we find that the legislation is repugnant to any central legislation, can it not reserve for the opinion of the president?
Mullahs, normally, Mullahs, there's the constitutionality of the presumption of constitutionality. Normally, no. That will apply to a bill also. It's been passed in the legislature.
No, but
it's a rare case. It'll be a rare case.
it's a rare case, but some like my Justice Narasimha give an example. If the state legislature passes a bill or legislate a law on the subject of shipping.
In the area of shipping.
Citizenship, take any number.
Let's assume, Mullahs, first of all, your lordship, these fact situations are never before the court. Mullahs, the point is, you are now taking an example that has never happened in the history of the Republic of India, and testing the proposition on the basis of 200 and 201.
Therefore, the question that we are putting is whether in such a case, can the governor not exercise his first option or second option?
It's in the rarest of rare cases, Mullahs. I'm saying that has never happened before. We are now assuming something that Mullahs, legislations are not passed like this, or not, bills are not introduced like this. Mullahs, supposing there is a price regulation in respect of drugs, Mullahs, how these bills are not introduced? You will ask the Ministry of Health, what's the impact of it on the consumer? You will ask the Ministry of Consumer Affairs, what's going to be the impact? You will ask whether under the drug control order you can do it or not. Should you do it? Should you do it with an essential drug? Should you do it with another drug? Then it goes to the Ministry of Law. These legislations are not passed on the ipsic dixit of ministers, Mullahs. Therefore, I understand what my lord is saying, but it's never happened.
Therefore, Mr. Sibal, even according to you, the governor will have to apply his mind at least to find out whether the proposed bill is within the constitutional framework or not.
Well, the problem is, I'm sorry.
Two expressions which I am again repeating, shall declare presupposes application of mind by the governor. And that application of mind, we can, of course, you can argue that what will be the contours of that application.
Yes.
The other side can also argue what should be.
Correct.
So within that framework, neither he can be treated as a postman, nor he can be a super legislative power to sit over.
Absolutely. No, your lordship is right.
Legislative assembly.
Your lordship, in fact, asked that question and said that I would address it, Mullahs. Now, let me address it straight away. Mullahs, the bill is sent to him. He doesn't have a formal declaration to be made. He assents to it. His assent is a declaration. Right, Mullahs? There has to be no formal declaration. Two.
Grant of an assent is a declaration.
It's a declaration. That's right. So there's no formal declaration, right? Two, he sends it back. Let's say he sends it back. It's a declaration. It's a declaration that he's sending it back and he's withholding assent. They go hand in hand.
If he sends to presidential assent, again it's a declaration.
That's right. Therefore, and it is withholding. Kindly note the word. Withholding assent is coterminous with his sending it to the legislature and sending it to the president.
What gets excluded is only a pocket veto.
That's correct. Correct. It's completely excluded. Now, the question that what my lord asked, so declaration is clear, Maharaj, it is the act of the governor to, which itself is a declaration. There is no formal declaration to be made, right? What your lordships are looking at, what are the contours of that? Namely, supposing he starts giving reasons, that this, for this reason, I am sending it back to you. Let's assume, Maharaj. Are those reasons justiciable? Parliament, the state legislature will say, we don't agree. The end of the matter. Even if he has reasons. He'll have to pass it. If it sends it to the president, Malas, and the president sends it back with the same, and still the legislature passes it, it'll have to be passed. So, Malas, the process is what's important. The sovereignty of the, sovereignty of the legislature is as significant as the sovereignty of parliament. And supposing all these, I'm sorry.
Thank to them.
That's right. Otherwise, it'll be a violation of separation of powers. So he can do that. So the question is, how soon should he do that? That's ultimately we boil down to that. He can do that, but how soon should he do that? The president does it forthwith, never delays it. Should the governor be allowed to delay it? That's the question. Right? Mullah, the home cannot function unless there is marital accord, Mullah. That equally applies to institutions. You can't create a discord. The marriage will break down. The constitutional machinery will break down. And the court must attempt to ensure there is no area of discord. So there the key words are as soon as possible. It was not later than 6 weeks. They said no, which means forthwith. Immediacy, element of immediacy. Why? The will of the people. Why should people have to wait if the rate of interest charged by money lenders is going to be 50%? Why should fishermen wait if the law is to be regulated as far as fisheries are concerned? Why should that wait? What's the reason? And the governor cannot say, I had no time. Well, there will be extraordinary situations, which is why it is very dangerous to lay down laws without context. This is a very dangerous area. Because then you give examples which are not before you. And then you test those examples on the basis of constitutionality. And those examples may be completely unrelated to reality. So you are given a situation where an argument is being made, give that discretion. Of course, the argument is extreme. He says, if I don't decide a bill for 3 years, it doesn't matter, or 5 years, it doesn't matter, because it is not justiciable. Constitutionalism has to be worked out.
No, the argument is that the governor has the power to permanently withhold it.
That's correct. So that's one extreme argument. If your lordships don't agree with that, we still have to find contours within which it must work, Malaj. The constitution must work in a manner that is consistent with the parameters set out in the context of separation of powers and the primacy of the legislature. So, Malaj, that's what I wanted to place before you, Malaj, before I move on, Malaj. Would my lords be, Malaj, you'll have to do me a favor, because now it is volume 2.5 and not 2.4, Malaj. Because I've incorporated, yeah, yes.
This is the latest.
Yes, I'm sorry. My mistake. Now, Malaj, I'll just cite 2 judgments on. I hope, Malaj, when it comes to writing a judgment, the wrong volume is not given to you.
Eight,
896.
we can discard this.
Yes, please, 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 please.
So, Nihal Lalu.
Discard that, please. The previous one also. There's a previous one which I did in the beginning, Malas. That also needs to be discarded. So, Malas, kindly come to Malas, volume 4, volume 2.5, page 893 and item 4, this judgment, NCT versus Union of India. Malas, just a couple of paragraphs. Yeah. I mean, I can understand the situation. There is a tsunami, whereas the state is, everybody is dealing with the tragedy that has happened 2 months past, 3 months, no problem.
Comes serious law and order situation.
Correct. Look what's happening in Himachal today. Look what's happening in Jammu Kashmir. Punjab, Punjab is totally inundated. See what's happening in Himachal. You see the timber that's coming down. It's just, one wants to cry as to what's happening in our country. Now, in that situation, there's maybe a delay.
Is appearing for Himachal Pradesh.
Yeah. So volume 36, PDF 103, page 13824.
13824.
Yes. And para 142 and 143. PDF page 103, Malas. It's easier to get that. 5.36, PDF 103. And paragraph 142. It'll take you directly to that paragraph.
Page
13824. Para 142. PDF 103. Okay. The room, I'm sorry, Malas.
Yes.
The room for discretion while interpreting constitutional provisions allows freedom to the judges to come up with a formula which is in consonance with the constitutional precepts, while simultaneously resolving the conflict in issue. The following observations in Bomai say, constitutional adjudication is like no other decision-making. There is a moral dimension to every major constitutional case. The language of the text is not necessarily a controlling factor. This is what my Lord Justice Narasimha put to me. Is not a controlling factor. Our constitution works because of its generalities and because of the good sense of the judges when interpreting it. It is that informed freedom of action of the judges that helps to preserve and protect our basic document of governance. It is imperative that judges must remain alive to the idea that the Constitution is never intended to be a rigid and inflexible document, and the concepts contained therein are to evolve over time as per the needs and demands of the situation. Although the rules of statutory interpretation can serve as a guide, yet constitutional courts should not, for the sake of strict compliance to these principles, forget that when the controversy in question arises out of a constitutional provision, their primary responsibility is to work out a solution, which is what I was mentioning to your lordships at the outset. Now come to Malat's page. This is PDF 1307.
Whose opinion is this, Mr. Sipa?
Give this position.
No. What is quoted of?
Justice Bomai, in Bomai.
Even ready.
Deepak, no,
No,
in
doesn't
Bomai.
matter. Doesn't matter. Sorry.
We just mentioned it, your lordship. Sorry. Now let's see the other judgment. Volume 8, page 3414, PDF 307. In the meantime, you find out,
Page?
Page 3414, Manoj. PDF 307. Para 90, Malad, at 30.
3114.
Para 90 is at the bottom of the page. Another principle which this, I'm sorry, my lords have that?
Yeah, para 90.
Nice. Another principle which this court has repeatedly laid down for cases in which two constructions may be reasonably possible is that it should adopt one which harmonizes rather than one which produces a conflict between constitutional provisions. Precisely the argument of the other side. You want to create a conflict. No justiciability. I can withhold. That's my power. And I can withhold for as long as I like. Courts, para 91. Courts have been advised to adopt the construction code, which will ensure smooth and harmonious working of the Constitution. I'm sorry, Mr. Justice Suryakant. I'm sorry. It was para 90?
Yes, 91.
Yes.
Courts have been
Courts
advised
have been advised to adopt the construction code, which will ensure smooth and harmonious working of the Constitution, and
Yes, Madam
eschew the other, which will lead to absurdity or give rise to practical inconvenience. Mullah, this is exceptionally important. Or make well-established provisions of existing law nugatory. Now see the consequence, mullahs. I'll now just to contextualize it. Governor says, I'm withholding the bill because I believe that it is unconstitutional for A, B, or C reasons. And the state passes it again. And he still withholds it. What's the solution?
But on the second occasion, we can't withhold it.
But if he doesn't, then?
Send it back only, then the legislature will pass it again, no?
Yes,
Correct.
yes. And
Only
he
if he
still
sends
withholds
back.
it.
If he doesn't send it back, then.
Still withholds it.
there is no-
Then what happens? This is why these observations. What happens? If somebody files a petition, governor can't be made a party. Who will defend the governor? Let's not interpret the Constitution to make it unworkable. That's the argument. Under 361, governor cannot file an affidavit. Court cannot issue a mandamus. If he chooses to voluntarily appear, he may appear. You can't interpret constitutional provisions to make the Constitution unworkable. And the language will not matter. The objective should matter. It's a living document. As I said, it owes its genesis to history, but it owes its allegiance to the future. And you are the future, because you interpret it. Let's not fall into a trap where the governor becomes an impediment in the functioning of the Constitution. Therefore, mullahs, you'll have to say something. Somebody has given a timeline of 3 months. Don't give a timeline, but you still have to say. Vichat had not seen, there is no way that he can withhold if it's passed again. Then you come to deem to. Then you say the court cannot do this. If you create a problem, you will have no solution. If you seek to resolve a problem, not over a cup of coffee, but constitutionally, you will have a solution. Huh? That's it, Mullah. That's on the interpretation, that's it, Mullah. I don't want to, there's no point in troubling your lordship. Now, let's come back to my propositions, and if your lordship is right. Huh? It was Justice Ahmadi in S.R. Bomai. Well, as I was on my propositions, where we reached. I'm not going to repeat anything, Malas, because what has been argued, I'm going to touch. Your Lordships always say, but you still repeat, Malas, I won't repeat. So far, I have not.
Time will tell, huh?
Paragraph 9 of my submissions at page 896. Under Article 163, the governor must also exercise his functions and act on the aid and advice of the Council of Ministers, with the Chief Minister at the head. Like the President, the governor is, as a rule, a titular head. Article 163, however, creates a narrow exception for the governor. Under 163(1), the governor must act on the aid and advice of the Council of Ministers, except insofar as he is by or under this Constitution required to exercise his functions or any of them in his discretion. The words by and under this Constitution and required in 163(1) are crucial and mean that the power of the governor to act in his discretion must be expressly conferred by the Constitution. Which is why I said yesterday, 200, the concept of discretion is alien to 200. It's a constitutional obligation. The words by or under required, once a constitutional provision provides specifically for the exercise of such discretion, then the governor's determination that a matter falls within his discretionary power is final and cannot be questioned on the ground that he ought or ought not to have acted in his discretion. Except for these provisions, the governor must act on the aid and advice of the Council of Ministers. The position is enunciated in Nabam Rebia. Now, Maharaj, I will not read the passages that Dr. Singh we read, Maharaj, but I'll read some other passages. Kindly come to paragraph, volume 22, page 8578. Can you give it to me? PDF 144. Paragraph 87. 87.
Page number?
Page number 8578. PDF page 144. Paragraph 87. The exact argument that was made by the learned solicitor about discretion under 163(1) and 2 was the exact argument made on behalf of the governor by 3 counsel and rejected. Now see Muller's para 87. It was urged that insofar as the present controversy is concerned, a correct understanding of 163(2), this is the argument of the governor in that case, would be of extreme relevance. Under 163(2), according to learned counsel, governor has the authority to act on his own. Same argument. In respect of matters where the governor is mandated to act in his own discretion by or under the Constitution. It was further submitted that when a question arises as to whether such discretion is vested with the governor by or under the Constitution, the decision of the governor on the above question is final and binding. It was submitted that 163(2) postulates 3 situations, whereas an exception to the general rule, the governor can act on his own will and discretion. Firstly, when he is required to discharge his functions by the mandate of some provisions of the Constitution itself, in his own discretion. Secondly, when the governor assigned functions on the basis of enactments made under the Constitution, where he is mandated to discharge his functions by exercising his own discretion. And thirdly, where he is impliedly required to act at his own discretion. Justice Nashima mentioned that to me yesterday. This is the very argument, Mullahs, that was made in Nabam. Now kindly come to paragraph 89.1. 8579. PDF 145. Well, that was the first time in the history of this court that a dismissed government was put back to a mandamus. Because the governor's action was found to be completely unconstitutional. He chose to summon the House on his own. He chose to fix the agenda of.
Kalyan Singh was also put back by court order.
Sorry, Madam?
Kalyan Singh,
Yes. Kalyan Singh, yes.
97.
Ah, okay. Now see, Mullahs, 89.1. Mullahs, I'll start with just above placitum B. Herein again. Your Lordship has that?
89.1 you were reading?
89.1.
Yes.
That's just above placitum B. Herein again it was
Yes, sir.
submitted that the governor would have no role except to the extent contemplated under Article 200. See, Mullahs, the 200 argument was also made. Wherein when a bill is passed by the House, the same has to be approved by the governor. And only when the governor gives his assent, the same assumes the status of a legislative enactment. It was pointed out that 200 contemplates a situation where the governor can return the bill with a message requiring the House to reconsider the same by examining the suggestions made by the governor. This limited responsibility cast on the governor, it was contended, fell within the legislative process. Argument rejected. The governor before whom a bill passed by the Legislative Assembly is placed has also the right to reserve the bill for the consideration of the President. This action of the governor, according to counsel, must be accepted as the further responsibility of the governor within the legislative process. It was submitted that all the functions vested with the governor under 200 are to be discharged by the governor in his independent discretion and not on any guidance or advice. This, according to learned counsel, illustrates the third category of governor's functions, wherein the governor is impliedly required to act in his own discretion, even though he is not expressly so required by any written mandate emerging from Article 200. Rejected. C 99. Page 8586. PGF 152. Paragraph 99, Mullahs, if I may.
Paragraph 99.
99. On the issue of discretion, the learned senior counsel placed reliance on 163(2). Based thereon, it was submitted that the governor's discretion for all intents and purposes must be deemed to be final. It was submitted that since 163(2) itself postulates that the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion, by itself absolves the governor from a challenge to the discretion exercised by him. Precisely the argument. It was submitted that 163(2) was neither a defunct nor a redundant provision, and as such it could neither be overlooked nor ignored. It was contended that the words employed in 163(2) must be given due weightage. If that was to be done, there could be no doubt that the discretion exercised by the governor under 163(2) would have to be considered in a manner as would protect him from the scope of any challenge. These are the contentions. Now I tell you, rejected. 147 and 149, if I remember.
Paragraph 147.
147.1, I think. 1 point, yes. Actually, it starts from starts at page 8617. So that's 147.2. 1. The executive functioning of states is provided under Part 6,
Paragraph?
para 147.1. Well, just come, let's skip I need not read the entire paragraph. Kindly read between placitum D and E. Starting, the question that will need determination at our hands. Your Lordship has that? Between D and E. The question that will need determination at our hands is whether the underlying cardinal principle with reference to discretionary power is to be traced to 163.1 or from 163.2.
Where are you reading?
Whereas between D and E, 147.1, starting, the question that will need determination.
Yes.
Lordship has that?
Yes.
At our hands, is whether the underlying cardinal principle with reference to the discretionary power of the governor is to be traced from 163.1 or 163.2. Whilst it was the contention of learned counsel appellants that the same is expressed in clause 1 of 163, the contention on behalf of respondents was that the amplitude of discretionary power of the governor is evinced and manifested in clause 2 of 163. Undoubtedly, all executive functions of the governor of a state are expressed in the name of the governor under 166. That, however, does not per se add to the functions of the powers of the governor. It is also necessary to appreciate that in the discharge of executive functions, the governor of a state has the power to grant pardons, reprieves, respites, remissions, or punishments, or to suspend, remit, or commute sentences. Governor's power under 161 is undisputedly exercised on the aid and advice of council of ministers. The governor has power to frame rules for convenient transaction of business. The instant responsibility is also discharged on aid and advice. All in all, it is apparent the governor is not assigned any significant role in the executive functioning of the state. We therefore endeavor to examine the duties and responsibilities of the governor, and then, para 148 at 18618, PDF 184. That's the final conclusion. 148. The above position, and Lordship has that? The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions as was assigned to him a dominant position.
Which is that paragraph?
148.
8618.
8619.
18.
Yeah.
8618.
18, not. Continues over page. Right, yeah.
I continued over the.
Yeah, yeah.
148?
148. I just read that. That really answers everything. The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions that would assign to him a dominant position over the state executive and the state legislature. The interpretation placed under 163.2 on behalf of the respondents has just that effect because of the following contentions advanced on behalf of respondents. Firstly, whenever a question arises whether he is discharging a particular function, the governor can or cannot act in his own discretion. According to the respondents, the discretion of the governor on the above question is final. Secondly, since the provision postulates that the decision of the governor in his discretion shall be final and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion, according to the respondent, makes the governor's orders based on his own discretion immune from judicial review. Accepting the above proposition will convert the governor into an all-pervading super-constitutional authority, which Dr. Singh we read. But it was important to read to go to the alap before we came to the conclusion. This position is not acceptable because an examination of the executive and legislative functions of the governor from the surrounding provisions clearly brings out that the governor has not been assigned any significant role either in the executive or in the legislative functioning of the state. That position adopted in behalf of the Sabha. So this rules out any possibility, and this is a constitution bench. That's all reflected in my propositions. So I'm not going to read them. Why waste time with your lordships? Now,
149 refers to
there's also 154. 154.
149 refers
Yes,
to the
149.
constitutional debates and
Correct,
Dr.
correct,
Ambedkar's,
correct. That also. Your Lordship is absolutely accepting the approach. And then, yes, all that will, Ambedkar is quoted and all that. And then it comes to one.
these debates were already.
Yes, therefore, I'm not going to take. Then come to 154.
622.
No, page 8622, Maharaj, PDF 188. But just above 154, Maharaj, just 5 lines above the previous paragraph, it is therefore clear, that is placetum, just above placetum B, A and B, the sentence, it is therefore clear. It is therefore clear that even though the governor may be authorized to exercise some functions under different provisions of the Constitution, the same are required to be exercised only on the basis of aid and advice tendered under 163, unless the governor has been expressly authorized by or under the constitutional provisions to discharge the function concerned in his own discretion. Maharaj, this is why I said in the opening, Maharaj, 200 is not one such provision. It's a constitutional obligation. You give him discretion, the Constitution will break down.
You gave yesterday, for example, 371A1B,
Yes,
where the discretion will be.
exactly. A1, H, 371. And that way the executive field, it's an issue of law and order. Maharaj, even there, the discretion is qua law and maintaining law and order. It is not with reference to any legislation. Even that discretion, Maharaj. Because otherwise he is to be guided by the advice of the council under 371A, Maharaj. There is a Hills Council, there are councils, Maharaj. So he may differ with that advice. And then if he differs that advice, that discretion is final in respect of law and order. Again, nothing to do with legislation. It can't be, Maharaj. It will be contrary to all principles of constitutional law if you start giving the governor that power. We're not going to have to find a solution, Maharaj. I come to that later. But first, let's be clear on the constitutional framework. We come to the solution in a while. So then it says, Maharaj, it is therefore clear that even though the governor may be authorized to exercise some functions, this is between A and B at page 8622, under the different provisions of the Constitution, the same are required. I've read that. Then 154, we therefore, of the considered view that insofar as the exercise of discretionary powers vested with the governor is concerned, the same is limited to situations wherein a constitutional provision expressly so provides, not by implication, expressly so provides that the governor should act in his own discretion, which is 371A, etc. Additionally, a governor can exercise his functions on his own discretion. Additionally, on own discretion in situations where an interpretation of the constitutional provision concerned could not be construed otherwise. We therefore hereby reject the contention advanced on behalf of the respondent that the governor has the freedom to determine when in which situation he should take a decision in his own discretion without the aid and advice of the Council of Ministers, Chief Minister and Council of Ministers. We accordingly also turned down the contention that whenever the governor in the discharge of his functions takes a decision in his own discretion, the same would be final and binding and beyond judicial review. We are of the view that the finality expressed in 163(2) would apply to functions exercised by the governor in his own discretion as are permissible within the framework of 163(1). And additionally, in situations where the clear intent underlying a constitutional provision so requires, where the exercise of such powers and the aid and advice would run contrary to the constitutional scheme or would be contradictory in terms. So, Maharaj, this clarifies many of the things, Maharaj, that have been contended on the other side. Now, Maharaj, my submissions. Para 14, yes. Now, Maharaj, another provision which I think my learned colleague, Mr. Kaul, referred to, which I think is also important, 167 of the Constitution. There are two provisions that are important for your lordships to consider, 158 and 167. first 158. The governor shall not be, my lords have that. The governor shall not be a member of either House of Parliament or of a House of the Legislature of the state specified. The reason why he is given a position because he is to act for the well-being of the state, which is why he is included in that in the provisions of the Constitution. Because he is acting on the well-being of the state. But he has no legislative role. Just that news. I just wanted to invite your lordship's attention. Now 167. My learned friend Mr. Cole referred to it. Rightly so, according to me. And this is where the hub will lie, Malas. Yeah, Malas?
Yes.
Yes. It shall be the duty of the chief minister of each state to communicate to the governor of the state all decisions of the council of ministers relating to administration of affairs of the state and proposals for legislation. To furnish such information relating to the administration of the affairs of the state and proposals of legislation as the governor may call for. And if the governor so requires, submit for the consideration of the council any matter on which a decision has been taken by a minister, but which has not been considered by the council. So, Maharaj, this is a pre-legislative process exercise. It gives you an indication of the contours of the power if it's to be exercised under 200. Well, that's why your lordship sees so often, and your lordship knows, every time the prime minister will go and brief the president as to what has happened. If he goes on a trip, he'll come back and brief him. If there are any proposals, he'll come back and brief him. There are, one nation, one election, he'll go to the president that, this is what we're contemplating. President may, in that informal discussion, this is Q 167, you have another provision, the same provision under the union. He will, have a So that's where the cup of tea happens, Maharaj. Not later. Exactly.
Not a cup of tea between your CM and the PM.
Yes. So this is where all the cobwebs are cleared. Once the cobwebs are cleared and the bill is sent to him, there is no occasion for him to say no. We have to work it out, Maharaj. We have to work out the scheme. So that's where, Maharaj, that conversation takes place. And then when the bill is sent to him, Maharaj, then he cannot say, I know I'm not going to accept it. I'll wait for 1, 2, 3, 4, 5 years.
From both sides. Right. Except.
We don't permit the constitutional
Right.
authorities to
I have done that, Maharaj. Yes, I've done that. Yes. I remember Maharaj S.V. Gupte was the Attorney General at that time as a young man, maybe 28, 29. And I briefed him in a matter and we were in outside court number 1. And matter was reaching and he was smoking Maharaj. And I said to him, Maharaj, matter is reaching. He said, yeah, it's all right. And it reached, almost reached. He said, you go. You argue. This is the kind of seniors we had. Now you want to take over even what the junior argues.
Therefore, we have stopped mentioning in the.
Now seniors
So
come for
glad.
seniors orders.
I am so delighted, Maharaj. That's the right thing to do.
Yes, I will.
Why should senior appear in vacations?
Yes, correct.
You should have this thing.
There is, in my court.
Practice procedure, Maharaj, should not appear in vacations. Anyway, that's another matter. I'll get into trouble with that.
Seniors need to get more disciplined now.
Only, I think you have exhausted all your 3 terms.
More or less, more or less. I'm going to, Maharaj, as I said, within,
You are exhausted all your 3 terms.
oh yes, of course, that, of course.
You don't have to bother about that.
No, but Maharaj, one is bothered for the institution. All kinds of things happen, Maharaj. Suddenly you find that your case is reaching somewhere else, so you stop the argument. This is not what. Anyway, that's another matter.
Yes.
Kindly come to Maharaj, back my volume 2.5. So, Maharaj, I was at, yes, I've already argued that what is there, Maharaj. I'm going to read it.
You're done?
I've argued, no, not yet. No, I will finish within the 4 hours given to me. Maharaj, I'll try and in fact give more time to others because there's no point repeating things.
Mr. Simple?
4 hours.
No, this says 3 hours.
That I don't know. I can finish in 3, no issue. I have no problems for us. And let us kindly come now to paragraph. I've done paragraph 15, 16. Then you come, I've also done 17, 18, Naban Rebia. I've read all that. Then page 8, 9, 9, 21. Declare, I've already done that. I've already done it. Well, let's not take the time of the court. Practice, Maharaj. If counsel do not sit in constitution bench matters throughout, they will be heard last. They'll make them sit, Maharaj.
Then by that analogy, Mr. Gopal Subramanian should have been the first one.
I'm ready. No, but we sat all throughout, Maharaj. We were there throughout. It's only some comfort break occasionally, Maharaj.
In between, you were going out for some time, but.
No, Maharaj.
Sometime, yes, we have seen.
Only to get the matter adjourned of that sort of pro bono matter.
But you took some 5-minute or 10-minute intervals.
Yes, but he's been throughout
He
here.
has been from morning to evening.
Which is why I've parted with Maharaj, the state.
And glued to the seat right from morning to evening.
Yes. And that's been our practice more or less, Maharaj. Now, sir, I've done declare issue, Maharaj. I've already indicated what that means. Then Maharaj 356. 356 is completely irrelevant to this issue. Because 356, again, as I told your lordships earlier, the only power of the governor under the constitution is either to accept what the legislature says or recommend. There is no third power of the governor. Under any provision. 356, he recommends. On what basis? On basis of satisfaction. Question of satisfaction is subject to judicial review, but not the judicial review that we contemplate qua administrative action. That's limited. He has taken irrelevant considerations into account. That doesn't apply to 200. 200 doesn't deal with either satisfaction or discretion. So those arguments, those submissions that they made under 356 have no relevance. On 161 pardon, again, it doesn't apply. And on 311.2, just see Malas 311.2. That's the other area. There are only 3 areas and all recommendation. 311.2.
You read it yesterday?
I didn't. 311.2 I didn't read.
No.
इन्होंने पढ़ा डॉक्टर सिंह
I mentioned it, I didn't read it. 111 I read, not 311. If you see 311 and you see, Malas, the proviso to subsection 2, sub-article 2. It says, I'm sorry, Malas, provided that where it is proposed that after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making a representation on the penalty proposed. Provided further that this clause shall not apply to come to B, where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded. So that's the other area. See that where the president of the case is satisfied. So both 356 and 3112 proviso deal with satisfaction.
Subject to satisfaction.
Yes, not relevant as far as 200 is concerned. So all this, and all this is recommendatory. Governor has no power. So either you comply with the legislation as proposed to you, or you recommend. Send it back, a recommendation. Send it to the president, a recommendation. No power. If you read into that a power, it will be contrary to this entire constitutional scheme. Similar as that's on para 2022. Then 200 I have done. I have also mentioned shall not assent to Malas in 200, second proviso, where the powers of the High Court. And my Lord the Chief Justice said that is clear that shall not assent to is different from withholding assent, where the constitution makers want it. So that is at para 24, Malas. I won't read it. That's already, huh? You want me to just read it? All right, 23 and 24 minutes, I will read on instructions. As such, the governor at page 900. As such, the governor has no discretion under Article 200. The issue of para 23 at page 900. Page 900, para 23.
And 900.
Yes, at 900. As such, the governor has no discretion under Article 200. The issue of discretion does not arise under Article 200. The provision imposes on the governor a constitutional duty to act in many of the 3 courses of action: assent, return, or reserve based on the nature of the bill presented to him. These are not discretionary choices, but constitutionally mandated routes. Now, how they are to be operated, we'll deal with it. The issue of whether the governor is to send the bill back or reserve it for the consideration of the president on aid and advice of the council of ministers is immaterial, as the governor is not vested with the power to take any final decision on the bill, except assent to it. As seen above, the power to withhold is only recommendatory. If the governor believes amendments are required, he may return the bill for reconsideration, but once the legislature sends it back, he shall not withhold assent therefrom. But the argument is he can still withhold dissent, and further, that he can send it again to the president. It can't be done. There is no choice. But once the legislature sends it back, he shall not withhold assent. There is no choice. Likewise, if a bill derogates from the powers of the High Court, governor shall not assent, but must reserve it for the president's consideration. In neither situation is the governor exercising discretion. He's only following the mandate of 200. Regarding the first proviso, 200 as separate from the substantive part creates an absurdity regarding money bills. That's something that your lordships mentioned. That if he can withhold assent, he can also withhold assent on the money bill. Because that's part of the proviso. But that will be an anomalous situation. So, therefore, I'll skip this, Mullah. Then Article 200 cannot be read in a manner to create constitutional impasses and litigation between constitutional functionaries. You can't interpret the constitution in a manner that will create more litigation. But personally, I think that 361 has not been accurately or constitutionally interpreted in the context in which it should be read. Otherwise, Balaj, you'll make 200 unworkable completely. The secretary of giving governor the power to reject a bill will inevitably lead to litigation between the state legislature and the governor, as it has, embroiling the executive and the legislature in protracted conflict, thereby paralyzing governance and defeating the spirit of parliamentary democracy. Conjured facts have no relevance to the issue at hand, Mullah. All these facts that my learned friend mentioned, if he deals with foreign affairs or the legislature deals, these are all conjured facts. And your lordship should not even look at it. You will decide a matter which is before you, not in the area of any situation which is a chimera, which has no relevance to reality, and you just conjure up something. I mean, legislatures, if you say the governor acts on the presumption that he is the highest executive authority and therefore acts with responsibility, the same assumption must be made in the case of the legislature, that they are acting with responsibility. Then, Malaj, in conclusion, para 29, in conclusion, an interpretation that gives the governor the executive power to withhold assent upends the entire constitutional scheme. The union's argument of separating the substantive part of 200 from the proviso allows the governor to avoid communication, bypassing reasoning, and ignore the primacy of the legislature, all while acting on his own and being immune from judicial review. This creates a one-time, first-instance veto, which is free from any kind of accountability. Such an interpretation builds a super-constitutional office wholly incompatible with constitutionalism, responsible government, and democracy. Then, Malaj, comes the timeline issue now. So, no more than 6 months, within 3 months, forthwith. Now it's the architecture that you create, which will be the law. And according to me, the following. All this confabulation must happen before the bill is proposed. Any problem that he has, and I'm giving a solution, any problem that he has must be communicated before. And once the bill is sent to him, he must assent. Right. There may be an extraordinary situation that may happen. I'll accept that there may be some situation where he still feels that he refers it to the president. Fine. But as soon as possible, forthwith must apply to the governor, must also apply to the president, because the president acts on the aid and advice of the Council of Ministers. So it's the government of India. It's not the president. So the same, what should I say, necessity of incorporating the concept of immediacy must be engrafted in the action of the president once the bill is sent to him, for he has to send it back. And if it's passed again, he can't say no. That's how the Constitution will work. Otherwise, it won't work.
There is a qualitative difference in Article 201 later part
I know.
as against the earlier
Correct.
article.
Correct.
It shall be presented to the president.
For consideration. But doesn't matter, Let's compare the government of India.
No, I'm saying that he must grant assent is what you say.
No, true, but I'm saying that. Supposing your lordships were to say he need not grant assent, you create the problem. Well, ultimately, you will have to decide how it works. Let's assume your lordship's thinking, let's take it forward, that he keeps it with himself. He doesn't respond at all. So the will of the sovereign legislature.
Founding. They are talking about a solution. Are we saying that the Constitution compels that a bills need to be assented?
Yes. Yes, absolutely.
It's like that unless.
Yes.
or else
No,
it
no, I agree. That's my constitutional premise.
Doesn't contemplate a situation.
Yes,
Where a legislature passes a bill.
yes.
And it is not assented to.
By the executive.
President, we are talking
The
about.
president is the executive. Because he acts on the aid and advice of
Ultimate
council.
analysis. From the legislature, it goes to the governor.
Yes,
It could go back to the legislature.
yes,
Then it comes back to the governor. Then first hurdle is that after that he can't refer it to the
Correct.
president. That's what, after he can't refer to the president. That also we need to find the textual requirement for that. And if it is permissible for him to send it, or even in the first instance, then the president considers, that's it. Constitutional text doesn't say that after his consideration.
correct.
Why is it that specifically it is chosen? So therefore, as a court, we need to supply those words.
Yes, yes.
Saying
Yes,
that the president has no option but to assent.
correct.
You want us to supply this?
Yes, yes, absolutely. Because that's the entire constitution.
In the context of the larger principle of
Yes.
parliamentary
Absolutely,
democracy,
absolutely.
federalism and separation.
Absolutely, absolutely. But the consequences would be disastrous. Point is, you are now a Hobson's choice.
So the constitution has not contemplated a situation where under the federalism, the union can not assent to a bill.
Yes.
To stop.
Yes. They will be challenged if ultimately, and you lordships will decide whether it was right or wrong. But he cannot say no. That's the only way the constitution will work. Won't work otherwise. It's the same. The same. But the point is, that's what I said. Exactly the same. So you can't have two different yardsticks. Otherwise, what happens, Malad? The executive exercises a power to overrule the will of the people, whether it's in the state or parliament.
No, but Mr. Simple, 111 end and 201 end are different. They are not the same.
Shall not withhold a
No, then it is only sent for his consideration. What does that mean?
But naturally, Malad, I'll tell your lordship. Your lordship is right.
Why it could have been said the same
Malad,
language as 111?
if it shall not withhold assent as far as 111 is concerned, will you read into the constitution that he can withhold assent?
That's what we're trying to find out.
Malad, therefore,
Why the language is differently used?
Malad, because nobody ever, when they framed the constitution, imagined that this would happen. It has not happened till 2022. Since 1950, it has not happened till 2022. This issue has not come up before. So you should not intervene.
Yes.
Well, ultimately, your lordships will, let's assume now that the fact that it says it for the consideration of the president, there is an element of space within the government of India can say no. Let's accept that. What's the consequence? Litigation. So to that extent, the bill will never see the light of day till it is decided up to this court. Does the Constitution contemplate a situation like that? It's the question your lordships will have to ask. And if it does, fine, Mullah. I only think it will create a lot of litigation for us.
Good for the bar.
Good for the bar. Correct. Very sad for the people of India.
Not good for the country.
I mean, constitutional provisions can't be interpreted in this fashion, according to me. It's a living document. It has energy. It has vivaciousness. Deals with situations that we see today cropping up, problems of governance, which we have never seen before. You have to resolve it constitutionally, not over cups of tea. Yeah.
This last question. Proviso, the earlier question, when it goes back
Yes.
from the governor to the assembly, and
Yeah.
the assembly sends it back.
Yes.
The second stage, what is there in the constitutional text to prevent the governor from referring it to the president?
Yeah.
First, from the text or the theoretical
Yes, flows.
or a principle,
Yes.
or the value of the democracy,
Right.
all right.
Right.
But from the text, is there anything
Correct.
that when it comes back to him after his message, what is there in the text to prevent him from not referring to the president?
The text says he has to accept it.
When it comes back,
Yeah, it says, shall not withhold assent therefrom. Therefore, he cannot withhold assent.
it doesn't say that it will have to be.
This is the only option. He has to withhold assent. He cannot withhold assent. That's what the Constitution
The
says.
later part you're saying. You're saying for the reason that the governor. shall-
Reconsider the bill accordingly, and if the bill is passed again, with or without amendment and
You're
presented to
saying
the
that the
government.
later portion will give the meaning.
Yes, exactly. Right. Therefore, Manoj, as far as the governor is concerned, he has to clear it. As far as the government of India is concerned, they need not clear it. Both are executive, Manoj. No, it's difficult to contemplate that situation constitutionally. So the proposition has to be, he has to clear it. There is an element of immediacy, must be done forthwith. As soon as possible means if it's impossible, that impossibility cannot happen in a constitutionally run regime. There can be no impossibility in dealing with the bill. So must be forthwith, not even 3 months, forthwith. There's an immediacy to the will of a sovereign legislature. And if he doesn't do it, Malaj, you will have to then, Malaj, create an architecture for making sure that the will of the people is represented through the legal process. The will of the people can't be subject to executive whims and fancies. Yes, there's a very Now, let us kindly come to Article 254(2). This is the issue of repugnancy, Malaj. Two 254(2). My Lord, the Chief Justice has it.
Yes.
Which one?
254(2). If I may, Malaj, read it. Where a law made by the legislature of a state with respect to one of the matters enumerated in the concurrent list, that's where the repugnancy issue comes up, Malaj, contains any provision repugnant to the provisions of an earlier law made by Parliament or an existing law with respect to that matter, then the law so made by the legislature of such state shall, if it has been reserved for the consideration of the President and has received his assent, prevail in the state. Now the proviso, provided that nothing in this law shall prevent Parliament from enacting at any time any law with respect to the same matter, including a law adding to, amending, varying, or repealing the law so made by the legislature of the state. So, Parliament has a way out. If they think it's repugnant, they can immediately pass a law. No need to send it back. And no need to withhold it. There is a constitutionally provided solution.
Prevention is better than cure, no?
Yes, absolutely. So the point is, Mullahs, there is a constitutionally provided solution in case of repugnancy. This is just a bogey, Mullahs. It's to make sure that these bills of the states are never passed. It's a constitutional anachronism, Mullahs, to interpret the Constitution in this fashion.
But it is in the context of your argument that bills which do not enjoy legislative competence, knowing very well when they are passed, though 254 applies, but nevertheless they need to be assented.
Yes, 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 absolutely.
So it's only in the later part
That's right.
that the court might set aside.
Correct? Absolutely.
But then the bills need to be passed.
That's right. Well, that's the will of the legislature. Well, it's sovereign. You can't have the executive becoming an impediment in the will of the people.
Theoretically, not
Yes,
that the state was going to do it.
not that they are, Manas. We are not. We're answering a question or of a reference. Therefore, I'm saying
A state's bill on citizenship
yes.
can't be stopped even by the president.
No, you're assuming now, Manas. That's
Theoretically.
no, you can't, Manas. I'm sorry, Manas. I'm sorry.
Theoretically.
No, no. Then I'll take other facts, Manas, theoretically, which will destroy the argument, Manas. What's the
It's your argument that it could be tested only in a court.
no, Manas? Your lordship is assuming that there will be a state legislature in this country. Manas,
That it will not be in a situation.
Manas,
I gave you an extreme example.
well, but that extreme example should not lay down. As somebody said, bad examples like bad law, Manas. Well, my lord differed with that, and I said,
Hard cases make good law.
that's right.
Yes.
So, Manas, yeah, these are assumptions made that they will pass a law in respect of foreign affairs, and then an argument is made.
So true.
If we are not going to deal with facts, then we cannot deal with these assumptions. When that issue comes up before your lordships, you will deal with it. But you can't deal with it in a reference without the fact. Because you are now assuming something. They say, don't refer to what West Bengal did, don't refer to what Tamil Nadu did, don't refer to these facts, but refer to my facts. Can't have it both ways. So I accept what my lord is saying, Malas, but that's not something that's going to happen.
You ask a question, it's intended for the interpretative.
I understand.
That's-
The interpretation is very simple. I mean, that's a constitutional thread that runs through the Constitution.
Those of us are well trained, so don't get upset.
Executive barred from interfering in the process of legislation. Constitutional bar. Therefore, this whole question about I'll have to file a writ petition and the governor will, it's all irrelevant. None of this should happen. Should be done forthwith. Only question will, even after it is sent by the legislature back, he still withholds it. Then what happens? That's the only area where your lordship will actually have to lay down. Now, whether it's deemed to be passed or what procedure you will create for the insurance, to ensure that the will of the people is carried forward, is you'll have to create that. I can't provide a solution for that. But remember one thing. Do not allow, as a matter of constitutional law, the executive to interfere in the will of the people. That's all. Well, it's theoretically, has any parliamentary legislation passed a law violating list 2? No. So if they do pass a law, what happens?
It was simple. Examining, let us say academically, there is no instance. The power of parliament under proviso 254(2) is not a substitute or is not to render the power of the governor to reserve a bill for the presidential assent as redundant.
You're right.
Those two powers are independent and they will coexist.
Exactly. No, I agree. I agree entirely.
There can be an example, say the governor may assent to a bill and that will become act. But in due course of passage of time, the parliament may experience that one of the provision of that act is repugnant and therefore the
Proviso comes in.
amendment is asked.
Correct.
That to that
Absolutely right. I entirely agree.
they find
Correct.
that it may create
Absolutely right. But that can happen at any stage. It can happen earlier also. It can happen straight away when the bill is sent and they feel that there's a problem and there's a problem of repugnancy, they can pass a law. So it can happen, but there's a solution provided in the Constitution. But that solution is not that I sit on it and not give assent to it. And that's true of everything into, but Maharaj, the other thing that I wish to say, and I say it a little later, I'll try and finish by.
in other words, the proviso under 254(2)
Yes,
is a second filter
yes,
that if a mistake is committed there,
yes,
parliament still enjoys that,
Exactly.
that power. Okay.
exactly. That's my submission, Maharaj. Now, let's kindly come to 34. So, Maharaj, basically 34 and 35, that the decisions must be taken forthwith. There is no question of 3 months, 6 months, 6 weeks, forthwith. Unless it's impossible, because that's as soon as possible. Right, Maharaj? And 36 says, the words as soon as possible in 200 refer to the hiatus between the presentation of the bill and its return for reconsideration by the legislature. Whereas what happens is there are a couple of stages here. Number one, you send the bill, he doesn't deal with it. So what happens to as soon as possible then? He just doesn't deal with it. And that's not hypothetical. So as soon as possible has no meaning. So he has to deal with it, and he has to deal with it forthwith, and he has to send it back. And the processes should be completed in under 167. And then there can be no impediment. If they are not completed, even then, he must forthwith send it back, whatever his comments are. Or forthwith send it to the president. He can't delay that also. Supposing he says, I'm sending it to the president, but I'll take 2 years to do that. He can't do that. So that your lordships will have to clarify as a matter of constitutional law. And if it reaches the president, the government of India must forthwith send it back with whatever comments they have. And we need not have to litigate on that. Once the declaration of the law is there, there'll be no litigation. Then come to 36. The words as soon as possible in 200 refer to the hiatus between the presentation of the bill and its return for reconsideration by the legislature. This phrase merely recognizes that some additional time may be needed when the governor chooses to withhold assent and send the bill back, and requires that even this be done with the greatest expediency. This absence of words as soon as possible in the substantive part does not permit endless deliberation. It indicates an inbuilt constitutional mandate that the decision to assent, withhold, or reserve must be taken even faster as soon as possible, that is, forthwith. Constituent Assembly originally provided, well, your lordship had that, 6 weeks and all, no repetition. Then, well, let's come to the, another argument made, which is judicially manageable standard. He said, look, there are no judicially manageable standards. If he withholds the bill, how are you going to decide whether he's right or wrong? There are no judicially manageable standards. But the concept of judicially manageable standards is not a matter of constitutional law at all. Well, that's directive principles of state policy. What your lordship says, these are the judicially manageable standards. How do we implement that? That's for the state to decide. Comes to equality, you say, we'll decide. All of part 4, duties of citizens towards the state, not judicially manageable. Because that's in the area of either policy or in the area that if there is a rule of evidence that in the absence of facts, you cannot do anything. I must pay allegiance to the Union of India. It's a duty, not judicially manageable. That's nothing to do with 200. So para 39, first, once it is accepted that the governor does not enjoy an untrammeled power to withhold dissent, the natural sequitur is that his decision must be taken within a reasonable time frame to reject the notion of an absolute veto while simultaneously holding that the courts cannot prescribe and enforce a timeline is to create a constitutional absurdity. It would amount to allowing the governor to sit on a bill indefinitely, thereby achieving through delay the very outcome of which the Constitution prohibits. So if you say, okay, he cannot withhold a bill, but you say that no, he can sit. When I send the bill to him, he can sit, Malas. That is also amounts to withholding the bill. If you reject that argument, you'll have to reject this. You can't have through an interpretive process the same outcome of withholding a bill because there's no timeline to be adhered to. So the timelines required are integrally linked to the process of immediacy and cannot be allowed to result in withholding the bill. It becomes clear when one considers the 3 stages to the time frame. When a bill is presented, the requirement as soon as possible demands that assent, withholding, or reservation be declared forthwith. If the governor fails to act, the court cannot prescribe a time frame. It is equivalent to conferring an indefinite veto. If you don't have a time frame, there will be a veto. 2, when a bill is returned to the legislature and comes back, Article 200 says governor shall not withhold assent. If no timeline can be enforced, the bill once again becomes again a veto. So the very malaise that you tried to prevent exists in not having a timeline, but it will amount to withholding. C, where a bill is reserved for the president, and that too must be done forthwith. If the governor chooses not to send it and the courts are powerless to intervene, it is nothing but a disguised power to withhold. So you come back to the same question. All right, don't give me the power to withhold, but don't give a timeline which would result in withholding. Cannot be, this cannot be a principle of constitutional law. So there are judicially manageable standards which are part of Article 200, are integrated into 200, in immediacy, forthwith, soon as possible, without delay, is part of the constitutional structure. So there's no question of judicially manageable standards. Then come to 44 straight away. Thus, time limits prescribed by constitutional courts under the circumstances above are not to be equated with judicially enacted constitutional amendments. He said, well, the argument was that, look, if you give a timeline, you're amending the article. Of course not. You're ensuring that the article functions, that the constitutional machinery functions. Not that you're amending it. It's an issue. As recognized in, let's leave that out. Then 545 mullahs. There is no automatic or self-executing consequence to crossing the time limit. It simply triggers judicial scrutiny. A timeline set by this court does not mean that the governor is mechanically bound to act within 1, 2, or 3 months in all cases. Rather, it means beyond the prescribed period. If an objection is raised, the governor or the executive as whole must satisfy the court that the delay was justified and free from abuse. Quite frankly, Maharaj, this is not relevant because that's not my argument. This is what the Tamil Nadu judgment says. Now, Maharaj, kindly see para 46. That's very important, Maharaj. The timelines prescribed by this honorable court are also based on the following. Maharaj, Tamil Nadu provided some timelines, but based on what? Office Memorandum of the Ministry of Home Affairs, Government of India, dated February 4, 2016, issued to all ministries and departments of the government, acknowledging the undue delay in clearing reserved bills despite an earlier guideline of 22nd September 92. The memorandum thus admits that decisions on reserved bills must be taken expeditiously. That's the memorandum on which was Tamil Nadu relied. So that's the constitutional purpose. Sarkaria Commission, Punchi Commission, both recommended timelines. I'm not on timelines at all, Malas. My argument is different. You give them timelines, they breach the timelines, you destroy the constitutional working of the Constitution. Then, Malas, judicial review. You want me to read it? Not necessary. I've already made the argument. Yes, yes. Then you come to
131.
no, kindly come to para 52, Maharaj. Para 52. Because my learned friend talked about justiciability. He said, it is not justiciable. It's not question of judicial review doesn't arise. Well, let's kindly see para 52. An absence of judicial review may be presumed in areas such as fundamental duties under Part 4A of the Constitution and broad economic policy. These are rules of evidence. You don't have the facts. Further, matters relating to relationships of confidence, which are protected by the concept of privileged communications, are not matters for judicial review. This is based on the principle that the rule of evidence does not allow them to be matters for judicial determination. Because you just don't have the facts. Similarly, acts of the executive in which law and order is required to be maintained in respect of in situ situations are again not matters for judicial review. 371A, 371H. This is reflected in the discretionary actions of the governor under 371A, which are pure executive actions and cannot be regulated through judicial determination. However, the principle does not apply to specified constitutional obligations of either the executive or the legislature. Well, another argument was made, see, you have timelines. Wherever the Constitution wants timelines to be provided, they are provided, but all of them are legislative. There will be a 5-year term of the Assembly. There's a 5-year term of Parliament. That's the bedrock of democracy, timelines in respect of legislation. Elections will be held in such and such time, within 6 months of the Assembly being dissolved. This is not in the functioning of the executive. If there exists a provision, the contours of which are clearly established, within which the executive or the legislature is to function, and which impacts Part 3 of the Constitution, or is reflected in constitutional provisions delineating the powers and responsibilities of the constitutional authorities, then such action is subject to judicial review and is justiciable. Article 200 is one such provision. It is not a provision that requires the governor to be satisfied, as in the case of 356. Therefore, the question of justiciability does not even arise. Thus, Article 200 is within the powers of the court's judicial review. Then, Malats, The judicial review is invited the moment he kindly come straight away to 59 now. Oh, sorry, what? 59, yes. Normal is 59 is Rameshwar Prasad, right? This is page 908. Malas, if I may, Malas, just read 361 with you again, Malas, if your lordship permits me. Just so that we clarify the contours of 361.
Yes, sir.
The president or the governor or Raj Pramukh of a state shall not be answerable to any court for the exercise and performance of powers and duties of his office, or for any act done or purporting to be done in the exercise and performance of those powers and duties, provided that the conduct of the president may be brought under review by any court, tribunal, or body appointed or designated by either House of Parliament for the investigation of a charge under 61, provided further that nothing in this clause shall be construed as restricting the right of any person to bring appropriate proceeding against the government of India or the government of a state. Just pause here. If you allow the governor the personal power to take a decision, neither the government of India nor the government of the state is involved. How will 361 apply when it's the decision of the governor that I will not give you a cent, or that I'm keeping the bill pending? Government of India can't defend him. Government of a state is at odds with him. How will a writ petition lie? You can't interpret 361 in this fashion. If you give that power to the governor, if you give that power, my argument is that you should not do so. But if you do give that power, then he's answerable. Then 361 will not stand in the way. Can't have it both ways. You take recourse to 361 saying he's not answerable, and you give him the power under 200, and you say government can't, governor will not file an affidavit, and court can't issue a process, then you're making the Constitution unworkable. Because that's the only act in which he is not accountable. There is no act in the Constitution which makes the executive not accountable to the court. But this is a provision where you will give that. You can't have an absence of accountability as a constitutional provision. Therefore, Maharaj, that's why I've been saying time and again, the governor has no such power. This situation should not arise, should not be allowed to arise, is not constitutionally permissible. He has to give assent. The president has to give assent. And litigation will take its course, whether it is repugnant, not repugnant, whether it violated a constitutional right of citizens, did not violate, whether whether the legislature had the capacity to enact the law. These are situations that will arise in the course of litigation, and you will decide. But he has no power not to assent. Only question your lordships have to do, if despite that he does, then what's the remedy? That's the only area where you have to create an architecture for a remedy. Either deemed assent or some other thing. Just wanted to flag that issue. for your lordship's consideration. Then, Malads, really, Rameshwar doesn't answer that question. I'm just, Malads, since your lordship said, doesn't answer that question. Because again, Malads, the problem that with us lawyers is the following, Malads, and I must concede that we are guilty of that. We take out a sentence from one judgment and we say that it's the exposition of the law, realizing that every judgment is contextual, arises from the facts of the case, has no bearing on another issue, which has, where the facts are not before you. And there are very famous words, which is not part of the, it's not part, but we've handed over a hard copy. Just have a look at that since I just finished this aspect. This is an Oriental Insurance Company versus Rajkumari. Para 11. Just give the judgment, please. I'm sorry, Malas, but we'll put it in the...
It's
25, okay.
So read 11 and 12.
Yes, yes. Yeah, yeah. Yeah. It's here. Yeah, this judgment at page 1146, Malas, on the left-hand side top, at the bottom, paragraph 11. 1146, paragraph 11. At the bottom, if I may read. Reliance on the decision without looking into the factual background of the case before it is clearly impermissible. A decision is a precedent on its own facts. Each case represents its own features. It is not everything said by a judge while giving a judgment that constitutes a precedent. The only thing in a judge's decision binding a party is the principle upon which the case is decided. And for this reason, it is important to analyze a decision and isolate it from the ratio descendi. According to well-settled theory of...
Said in Dhanvantari Devi.
Yes, exactly. That's why, Malas, in the 2G case, when auction was prescribed for telecom, in the telecom sector for spectrum, the question arose, does it apply in every other case? And your lordship said, well, as far as spectrum is concerned, it's fine, but it can't apply to other cases because the fact situation is different. So, Maharaj, how can a principle of law, say in Nambudiri, for example, it was said that the House stood dissolved, the Assembly stood dissolved, and the matter was pending before the President. And since there was no timeline, even if the Assembly is dissolved, the bill can be passed. Right, Maharaj? That's what Nambudiri says. The argument is the court has said no timelines. Therefore, no timelines in 200. What's the relevance of that to what we're discussing today? So you can't take a judgment like that and set up a constitutional principle that no timelines will apply in 200, when that was not the issue before the court. The question is whether the bill survives or not, because it's awaiting the consent of the President, and the court said it survives. That's the mistake we commit. So it says, findings of material facts direct an inferential finding of facts is the inference which the judge draws from the direct or perceptible facts, statements of principles of law applicable to legal problems disclosed by the facts, judgment based on combined effect of the above. A decision is an authority for what it actually decides. What is of essence is that in a decision is its ratio, and not every observation found therein, nor would logically flow from the various observations made in the judgment. The enunciation of the reason or principle on which a question before a court has been decided is alone a binding precedent. Case is a precedent and binding for what it explicitly decides and no more. And this goes on, Maharaj. Courts should not place reliance on decisions without discussing as to how the factual situation fits in. That's para 12. with the fact situation of the decision on which reliance is placed. Observations of courts are neither to be read as Euclid.
That's what Dhanvantari there says.
That's right.
Slight distinction in fact.
That's right. So well, let's not.
With application of the same law.
Yes.
Will lead to divergent results.
Correct. So you can't apply 356 to 200. You can't apply Nambudiri to this. You can't apply Veluri to this. Then, this is at 909, para 60. I've done my argument on 361 already, so I will not read it, It only talks of 361. Then comes, the 131 and 132. Now, before that, kindly come to an issue that I wish to raise, not on maintainability, but kindly have a look at, where's that table? No, the table where, previous table. Yes. Annexure A, page 911, Now, I have set out here all references made in the past, all references. And no reference in the past is similar to this one, because in each reference, there is a specific question asked. In each reference. I'm not on maintainability. But I would request your lordships to be careful when deciding a matter of this nature, dealing with a hypothetical situation in the absence of facts. What has been directly argued is that the governor has immunity, that he can withhold assent, that your lordships must answer. But there are several peripheral issues which are not before you. It's not on maintainability, it's the discretion of the court whether to answer all the questions or not to answer all the questions. Now kindly look at this chart at page 911. Delhi Laws Act 1912, in re 1951, SCC 568. What is the question? Was Section 7 of the Delhi Laws Act or any of the provisions thereof, and in what particular or particulars or the extent ultra vires alleged? Would direct question, Mother, that your lordships had to answer on the light of the law that was operative. Then Kerala Education Bill, 1958 reference, does subclause 5 of 3 of Kerala Education Bill read with clause 36 violates, offends Article 14? Direct question. Come to Berubari Union, famous case, direct question. Kindly come to Sea Customs Act, 1963 Supreme Court. Direct, do the provisions of 289 of the Constitution preclude the Union? Direct question. Privileged immunities of state legislatures? Direct question. Presidential reference, 1974? Direct questions. Special bill, special courts bill? Direct question, whether the bill or provisions thereof, if enacted, would be constitutionally valid. In fact, Justice Chandrachud in this judgment, Senior Chandrachud said that, look, even this is very vague. You should have told us which are the provisions that should be held to be invalid. The court is not here to tell you whether the court is not performing that exercise. You want to ask me a question, you ask me a question. I'll right side that just now. Kaveri water dispute, direct question. Ismail Faruqi, direct question. Special reference, 1998, direct question. Jammu Kashmir grant of permit of resettlement, direct question. Special reference 201, direct questions. Special reference 202, direct questions. Natural resources allocation, direct question. Tell me which reference has ever been made like this? You're asked to answer on all kinds of assumptions. All kinds of scenarios are put before you. Is that the duty of the court? To not conjure up scenarios and then answer a question? What will happen in 131? What will happen in 32? When it happens, and you'll answer that. You'll answer that through your judicial process. Well, you're not going to take examples like that and answer questions. It's the job of the government or the president in the reference to tell you, this is what we are troubled by. Does arise or likely to arise? How does Miller's 131 likely to arise? Or 32, whether it lies or not likely to arise? How is it relevant? So Miller's, now let's look at that. First of all, Miller's what Justice Chandrachud said in Rebel. Which is that? Volume 9. Page 3685, PDF 184, para 30. This is where they said, you just tell us whether the bill is unconstitutional or not. What does Justice Chandrachud say?
Page number?
Page 3685, PDF 184, paragraph 30, volume 9. You'll just have it, Millet? My Lord Chancellor. Where has it? May I read it, Millet? May I read it, Millet? We hope that in future, whenever a reference is made to this court under 143 of the Constitution, care will be taken to frame specific questions for the opinion of the court. Fortunately, it has been possible in the instant reference to consider specific questions as being comprehended within the terms of the reference. But the risk that a vague and general reference may be returned unanswered is real and ought to engage the attention of those whose duty it is to frame the reference. Were the bill not as short as it is, it would have been very difficult. It would have been difficult to infuse into the reference the comprehension of the 2 points mentioned by us above and which we propose to decide. A long bill would have presented to us a rambling task in the absence of reference on specific points, rendering it impossible to formulate succinctly the nature of the constitutional challenge to the provisions of the bill. And somewhere else it is said that it can't be hypothetical. Yes, then Miller's para 26. This is very important. Para 26 at page 3684. The second objection, this is an objection to maintainability. I'm not on maintainability, Miller. We're beyond that. The second objection to maintainability of the reference is that it is vague, general, and of an omnibus nature. The question referred to by the President in this court is the following: whether the bill or any of the provisions thereof, if enacted, would be constitutionally valid. It is true that the reference does not specify with particularity the ground or grounds on which the bill or any provisions may be open to attack under the Constitution. It does not mention whether any doubt is entertained regarding the legislative competence of the Parliament to enact the bill, or whether it is apprehended that the bill, if enacted, would violate any of the fundamental rights, and if so, which particular fundamental right or rights. A reference in such broad and general terms is difficult to answer because it gives no indication of the specific point or points on which the opinion of the court is sought. It is not proper or desirable that this court should be called upon to embark upon a roving inquiry into the constitutionality of a bill or an act. Such a course virtually necessitates the adoption of a process of elimination with regard to all reasonably conceivable challenges under the Constitution. It is not expected of us, while answering a reference under 143, to sit up and discover, article by article, which provision of the Constitution is most likely to be invoked for assailing the validity of the bill if it becomes law. The court should not be driven to imagine a challenge and save it or slate on hypothetical considerations. Save it or slate on hypothetical considerations. As observed in Hamilton, speculative opinions on hypothetical questions are worthless, and it is contrary to principle, inconvenient, and inexpedient that opinion should be given upon all such questions at all. It applies directly to this case.
Read 27.
We are at one stage of the arguments so much exercised over the undefined breadth of the reference that we were considering seriously whether the circumstances it was not advisable to return the reference unanswered. But the written briefs filed by the parties and the oral arguments advanced before us have, by their fullness and ability, helped to narrow down the legal controversy surrounding the bill and to crystallize the issues which arise for our consideration.
In
We
2G,
close to the-
in 2G, DK Jain explains
Yes,
what is to be done by a reference court
yeah.
when there is uncertainty about the
Yes.
claim.
Now, if you look at the questions here, you are conjuring up issues, Manoj, which may never arise. Now, just look at the questions, Manoj. My iPad, yes. I'm not going to delve much on it, Manoj, just so that you have to, in ultimately deciding this matter, have to be careful where you want to give an opinion and where you don't want to give an opinion. Volume 3, Manoj. Page 7.
Volume 3, page,
Manoj.
3 page 7.
Page 7, Manoj.
PDF page 7?
Volume 3, page 7, Manoj.
Index of the-
Index and documents, volume 3, Manoj. It's part of the
Okay, you come to volume 3.
volume 3, Manoj. Index of documents, volume 3, Manoj, page 7. It's now, as far as 1, 2, and 3 are concerned, they arise. Only they are specific.
Yes.
I have no problems with that. 1, 2, and 3. Though constitutionally, 1, 2, and 3, Manoj, whether constitutional options before a governor when bill is presented to him under 200. I mean, it's not in the context of any facts, Manoj, but let's assume, Manoj, that your lordships can consider reading 200 and answer that. Then is the governor bound by the aid and advice standard? Let's assume that. Is the exercise of constitutional discretion under 200 justiciable? Then Article 361 is an absolute bar. Manoj. How does that arise? What's the relevance of that here? No such thing has happened. Why should you answer it? The absence of constitutionally prescribed time limit. Why do you assume that? You're going to interpret 200, interpret 200. You can't assume that there is no prescribed time limit. How do you assume that question? Assume that it requires to be decided. You interpret 200 in the matter that constitutionally, and then that will be the end of the matter. Why do you assume that there are no constitutionally prescribed limits? This is an assumption made, Manoj. Can't be a question on an assumption in constitutional law. Is the exercise of constitutional discretion of the president, this all part of 200. And that's not arisen in any situation, Maharaj. Kindly see. This question of 201 has not arisen in any situation. You're asked to answer the question. In a fact situation, if it arises, you will answer it. At the moment, it is obvious, Maharaj, and I can say it up front. It's obvious there's a judgment of this court and somebody wants to say that, no, that's not good. In the light of constitutional scheme governing the powers of the president, is the president required to seek advice of the Supreme Court by way of a reference? You're directly dealing with the judgment. If that arises, you decide it. But you're directly dealing with the judgment, which is prohibited, as you know. It will be challenged, Mullahs. I'm sure it will be challenged. You may set it aside. No problem. But this is no way, Mullahs, to get an answer. Are the decisions of the governor and the president at 201, 200, 201 justiciable at a stage anterior to the law? How is that? Is that arisen anywhere, Mullahs? Anterior to the law? Has it been said by any judge, Mullahs? Can the exercise of constitutional power and the orders by president be substituted in any manner under 142? Not arisen. It has arisen in a particular context and the particular facts of a case which was rendered, on which a judgment has been rendered. You can't tangentially, Mullahs, attack the judgment in this manner. Yes, you can say that judgment is wrong and it will happen. It will happen one of these days in some other case. You go for review, you go for curative, or you in another case, attack it. And many a time your lordships have changed your mind. There's nothing wrong with that. Is the law by the state legislature a law enforced without the assent of the governor? How is that arisen? Then 145.3, then 142, then 131. All these questions, Mullahs, with the greatest respect, should not be answered. The only parameter that needs your lordship's careful consideration is Article 200 of the Constitution in the context of the power of the governor. Nothing else has arisen. So it's not about maintainability. It's your lordship's discretion in the exercise of your constitutional duty through a reference that is asked for to answer questions that you might wish to answer, might not wish to answer. As I go back to my submissions, 2.5. Now, what is left? Well, I'm not going to argue 132 because I think it shouldn't be answered, Mullahs. I've done, Mullahs. I'm deeply, deeply obliged. I have, Mullahs, not repeated a single argument, and I have tried to save time so that my colleagues can argue.
But before my learned friend starts, on the lighter side, while arguing on the maintainability on the first day, since Dr. Singh led the arguments, but my learned friend Malad did not, but virtually he did that at the end in a different form, that it should not be answered because it is not made.
Some may be answered, some may not be answered.
No.
He is supported by judgment of the Supreme Court on that.
Yes.
He first referred to the judgment, Justice Chandrachud's.
I will deal with that, Malad.
You may
If you would have argued that at the outset, I would have dealt with that.
I never,
then.
in fact,
Now I will argue. We will, Malad, deal with those judges.
I never wish to argue maintainability because I don't believe that it is not maintainable. But I do wish to argue that many of these questions should not be answered.
Yes, Malad.
And I'm entitled to argue that.
How?
That you may do it in the rejoinder.
In my rejoinder, Malad, without the flavor of my learned friend. I'll argue about straight
No, but
answering.
he has his own peculiar favor in every case,
Yes.
which we appreciate.
Yes.
Deeply obliged.
Obliged.
What has been decided by your side with regard to request of Mr. Anand? No, that is an issue to be decided amongst yourselves, so. Yes,
You take an hour, then he has enough time.
we'll be finishing within an hour.
An hour, maybe an hour and 15 minutes.
Then it will be done. No issue. I said, you get somebody else briefing and saying that.
My Lord, I want to place the matter on behalf of the state of Karnataka on principles of constitutional interpretation. And I think, my Lord, the reference seriously entrenches upon one of the most acknowledged, consistent, and coherent principles of the Constitution, which is, my Lord, the democratic organ which enjoys executive power is the cabinet form of government. And this, my Lord, is central to the issue, because if the cabinet form of government is the quintessence of a parliamentary democracy, which your lordships have upheld, reinstated, reiterated, right from, my Lord, 1954. And if that is so, then, my Lord, one has to discover what is the role of the president and the governor. Unless, my Lord, we have this picture clear, we will not be able to answer the question with reference to Article 200. My Lord, the law has taken a consistent position right from 1954 that both the president and the governor are titular heads. And the true executive power resides in the cabinet, the ultimate cabinet, whether it is the union cabinet or whether it is, my Lord, the state legislature. In fact, my Lord, Dr. Ambedkar, very far-sightedly, in a speech of 26th of November 1949, amply clarified that both the central government and the state government, both the central legislature and the state legislature, have independence and are meant to be treated equally. I will not place that except from the speech. But, my Lord, there is a second principle on which your lordships will have to entertain this reference, which is the theory of collective responsibility to the House. Well, there are two principles. One is the cabinet form of government. The second is that cabinet form of government is collectively responsible to a legislature. Well, both these principles will be violated if either the governor or the president, my Lord, is given or is endowed with any form of discretion. If anything is to be indicated, my Lord, it has to be found in the text of the Constitution. For instance, my Lord, the president, after the 44th Amendment, by virtue of the first proviso under Article 74(1), can remit a matter to the cabinet for reconsideration. But after it is reconsidered, the advice is binding on the president. Under Article 103, my Lord, in respect of a disqualification, he is bound by the advice of the Election Commission. In order to discharge a judicial function about the age of a judge of the High Court, under Article 217(3), he consults only the Chief Justice and acts independent of the aid and advice of the Council of Ministers. These are the only two exceptions, my Lord, for the president. As far as the governor is concerned, my Lord, there are three sets of functions. The first is executive power, which is vested completely in the governor. The second is, my lord, he enjoys no legislative power. My lord, please take it from me. He enjoys no legislative power. The third is, my lord, functions for discretion are specifically nominated in the Constitution. And functions for reservation for consideration of the president are also identifiable in the Constitution. So, my lord, the question of high constitutional functionary enjoying plenitude of discretion, my lord, is completely anathema to the Constitution. And more than anything else, my lord, Keshavananda Bharati was resting on the pillars of the parliamentary form of government where the cabinet exercises the real power. In Keshavananda Bharati, your lordships equated the governor and the president in the constitutional sense in totally equal terms. So, my lord, I would submit with great respect that the first question for consideration is, what is the true relationship of the president and the governor to the cabinet government? This is the first question. And it is only then, my lord, we can come to the second one relating to Article 200.
Should we start at 2 o'clock?
Very well.